Good afternoon, everybody, and welcome to our program. Before we begin, we have our new FLABOTA president, Alex Reboso, who would like to say a few words.
Tammy, can you hear me okay?
Yes, we can.
Fantastic. Well, good afternoon, everybody. As Tammy mentioned, my name's Alex Reboso. As of Saturday night, I'm the new president of the Florida chapters of the American Board of Trial Advocates. That's FLABOTA. And I want to welcome you all to the 2025 Florida Rules of Civil Procedure update presented to you by the Fort Lauderdale chapter of FLABOTA and ABOTA, and in conjunction with the FLABOTA Scales of Justice CLE series. I think you're in for a fantastic and informative program. I see you have a fantastic panel of judges. I hope you enjoy it. I hope you learn a lot from it. And so I'm going to turn this back over to Tammy Alvarez. She is our Fort Lauderdale chapter ABOTA president and the moderator for today.
Thank you, Alex. Again, welcome everybody to our updated program on the Florida Rules of Civil Procedure. Some of you may know that this is a follow-up to the program we put on about 6 months ago. We have a different panel with us today. Nonetheless, another amazing panel. I have 3 judges with me today. I'm going to introduce. The first one is Judge Jeff Levinson. He did his undergraduate work at Johns Hopkins University, got his JD from the University of Maryland. He began his career as a trial attorney for the U.S. Department of Justice in the tax division. And he's been a prosecutor and an assistant U.S. attorney with the Southern District of Florida. Shortly thereafter, he was appointed to the bench by our Governor Jeb Bush in 2003. Judge Levinson currently presides in the Circuit Civil Division, and he teaches trial advocacy as an adjunct at St. Thomas School of Law. Welcome, Judge Levinson.
Thank you for having me.
You're welcome. Next, we have Judge Dan Casey. Judge Casey got his undergraduate degree at Wheeling College in West Virginia, and he got his JD with honors from Georgetown Law. He began his career as an ASA in Miami in the 1980s, where I'm sure he got a lot of high-level trial experience back then. He then transitioned to the private sector with Kirkpatrick and Lockhart, which is now K&L Gates, where he assisted growing the firm to a global 20 firm with over 2,000 lawyers within 48 offices and 5 continents. Judge Casey was elected in 2018 and now presides in our Circuit Civil Division here in Broward. Welcome, Judge Casey.
Thank you.
And last but not least, we have Judge Michelle Tobin-Singer, who was born and raised here in South Florida. She got her undergraduate degree at Brandeis University and her JD at Boston University School of Law. She part of her early career was as a public defender down in Miami for over 17 years. And not only did she try first-degree murder and felony cases, she also trained the incoming felony lawyers. She was elected to the bench in 2006, and she also presides in the Circuit Civil Division here in Broward County. She also is an adjunct professor at St. Thomas School of Law, teaching judicial internship and trial advocacy. Welcome, Judge Tobin-Singer. You're on mute.
Technology. Thank you, and thanks for having me.
You're welcome. Before we begin our program today, I just have a couple of short announcements. This program has been approved by the Florida Bar for 2.5 CLEs. The course number will be provided at the end of the program. We have been approved for a 1/2 credit in professionalism, a 1/2 credit for mental health and wellness, and a 1/2 credit for technology. The last announcement before we begin is we urge you to submit your questions early. You can do that via the chat function. We would like to get to all questions, but as some of you may know, we were not able to last time, which is why we urge you to get your questions in early. So why don't we go ahead and begin? And I'd like to begin with Rule 1.280, the general provisions governing discovery. And Judge Casey, if you would like to start us off, we would appreciate that.
Surely. Good morning, good afternoon, everybody, and welcome. First thing to note, we already have an approved amendment to the new rules, hot off the presses. It was issued by the Supreme Court on June 19th, 2025, and effective immediately. It is an amendment to Rule 1.280 sub F sub 1, important part entitled Timing and Sequence of Discovery. The former language said timing. A party may not seek discovery from any source before the party's disclosure obligations are satisfied. They changed that to the new language. Timing, a party may not seek discovery from any other source before that party's disclosures are served on the other party. So rather than the amorphous concept of they're satisfied, it's been changed to literally something far more concrete, something I can judge a whole lot easier whether they've served their discovery. Let's talk a little bit about the first topic, which I think everybody's interested in, and that's initial disclosures. Those of us who remember when we changed in the federal court system from up to the current process of cards on the table discovery, that's what we're going through now here in the state court. It says literally a party must, without awaiting a discovery request, provide the other party certain initial items of discovery. And the initial disclosures have to be made within 60 days of the service of the complaint or joinder, unless a different time is set by court order. So what has to be contained in the initial disclosures? Well, there's several categories of information. The first is witnesses. You need to name and provide the contact information for each individual, quote, likely to have discoverable info, along with the subject of that information that the disclosing party may use to support its claims or defenses, unless solely for impeachment. So the first category is witnesses. The second category is documents. Sub B talks about a copy or description of category and location of all documents, ESI, and other tangible things that the disclosing party has in its possession, custody, or control that the party may use to support its claims or defenses, except, once again, for impeachment matters. Third category of things is also a subject that I'm sure will come in front of me much, and that is damages. The initial disclosures need to contain a computation for each category of damages claimed by the disclosing party and a copy of the documents or other evidentiary materials on which each calculation is based, unless privileged or protected from disclosure. Party is not required to provide a calculation for non-economic damages, but the party must identify categories of documents claimed and provide supporting documents. The final category deals with insurance policies and indemnification agreements. These disclosures are required, but there are some reasons why you might not have to. A party is, but the new rules spend more time talking about what you're not allowed to use as an excuse. So for instance, a party is not excused from making its initial disclosures because it has not fully investigated the case. The party is not allowed to excuse its initial disclosures because it challenges the sufficiency of another party's initial disclosures or because another party has not made its initial disclosures.
Judge Casey, can I interrupt you for just a moment? With respect to the initial disclosures and not having the opportunity to fully investigate your case, speaking from a defense perspective, how would the defendants go about disclosing their witnesses, their documents that they plan on using?
Well, the rule's pretty clear. Everybody has to give their disclosures. Even the defendants have to do it within the same time frame. They need to give everything what's in their care, custody, and control. It's not an excuse that they haven't had time to investigate the case. But I suppose that what I'm going to be seeing going forward is people making their best efforts to disclose within the 60-day time frame. And then as other things come up, though, as I'll get into in a moment, there's also a duty to supplement. And I assume that there'll be lots of defense information provided in supplementation. But once again, they've got to be, otherwise they can be sanctioned. They've got to produce everything in their care, custody, and control that follows under each of the categories as best they can.
Is there a different approach how you perceive it with a plaintiff versus a defendant?
Yeah, I think there is. I think that the plaintiff obviously is in control of what it knows. Plaintiff is under an obligation in the beginning to only bring good faith claims based upon the information that it has. So it has the obligation, but also the opportunity to do a full case investigation before it pulls the trigger on filing the complaint. Defense don't have that same, they have the same obligation to provide documents that they know about or information that they know about, but they haven't had the time. So I see myself in time applying the same standard, but recognizing the difference of circumstance between plaintiffs and defendants.
I don't know about you, but I really haven't had matters before me addressing these issues. Have you?
I'm shocked. Neither have I. And Judge Tobin Singer can talk about whether she has. But I expected this to be a big topic. I still expect it to be a big topic in the future, but I haven't had a single initial disclosures matter come before me. And I haven't had, which is the first thing I expected, a single motion asking to be excused for good cause from the initial disclosures. I expected to have had motions by now, but I haven't. Neither you, Judge Levinson?
I have not.
Judge Casey, when dealing with the damages issue on a plaintiff's perspective, having to do the computation of the category of damages, I'm assuming we're talking about medical expenses, we're talking about lost wages, future lost wages. Can you explain what you would expect an attorney to have to disclose with respect to those categories of damages?
Sure. The economic damages need to be, you basically, once again, we're going back to that concept of cards on the table from the very beginning. They need to be able to a calculation of each category of damages is what the rule says, and turning over either the documents themselves or the categories of documents and their physical location that support those calculations. And I expect, and once again, if new things change, they also have to supplement as the time comes.
And I'm sorry, I didn't mean to cut you off, Judge, but I wanted to get those questions in because I know those have been hot topics.
Yeah, no. Those are, and it's once again, both Judge Levinson and I are surprised that we haven't been called upon more frequently on that topic. Right. Next thing I wanted to talk about was proportionality, the scope of discovery. It is now a way of life. We're not going to talk anymore about or could lead to the discovery of admissible evidence. We're talking about what needs to be turned over under these circumstances that we reasonably should expect. So they relied upon the issue of proportionality. And the rule says parties may obtain discovery regarding any non-privileged matter that is proportional to the needs of the case, and then lists 6 factors, all of which could be competing with each other. Things like the importance of the issues at stake, the amount in controversy, the party's relative access to the relevant information, the party's resources, the importance of the discovery, and the burden or expense of the proposed discovery. So once again, in federal court, remember we kind of addressed the issues of proportionality a while ago. Now it's coming to roost back in state court.
With respect to the proportionality and discovery motions that are probably going to be brought, we are not going to have case law now with respect to defining proportionality, whereas we have had the case law on whatever would lead to the discovery of admissible evidence. What do you foresee basing your ruling on when you take into consideration these 6 factors that you've listed?
No, I'm going to try and take into consideration the 6 factors as best I can. And the idea behind this is we can't let discovery get out of control, which it can in certain cases. It has to be appropriate. You don't have to kill a fly with a sledgehammer. And so I'm going to look and try my best to interpret the plain meaning of each of these factors. You're right; it's going to be a while before we get any overriding case law, and that case law very well as it does in its early iterations could be conflicting. But yeah, I'm just going to try and go by the 6 factors. They're pretty broad. And as everyone knows, it's going to be based upon the circumstances of the individual case.
Have you had any motions on motion calendar that deal with proportionality?
I haven't had any that called it that yet. By the way, I'm surprised at that too. I expected to have some by now. I haven't had any that called it yet, but there have been circumstances where I brought up the concept of proportionality in order to address motions. Remember, folks, these new rules, the initial disclosures apply to cases filed after January 1st of this year. Vast majority of the rest of the rules apply to all cases now. So the proportionality rules work now in order to be applied. How about you, Judge Levinson? Have you had any proportionality?
But just like you, I have brought that issue up. When you see it looks like it's overkill, we try to manage the case.
Judge Tobin Singer?
Same. I haven't had the parties actually bring up the proportionality standard. Instead, they're still arguing the old standard, but yes, I apply the proportionality standard as well.
All right, let me just talk a moment about supplementing, because that's something that's also new with the rules. A party who has made a disclosure under the rule or who has responded to any interrogatory request for production or request for admission must supplement or correct its disclosure, A, in a timely manner, and B, if a person learns that in some material respect, the disclosure or response is incomplete or incorrect. And there's also another exception. If the information you're looking to supplement is already in the record from someplace else, you don't have to do it. Once again, I've only had a couple of matters come before me so far on supplementing. We have worked through the various issues. There are sanctions for not supplementing that I'll get to in a little while, but it's an important rule that needs to be followed now.
Does the supplementing rule take effect for cases that were filed before the standard was changed?
From my understanding, it does.
Okay. So going forward from now on, we all have the duty to supplement, whether it's initial disclosures and or discovery responses.
Right. And in some ways, it's going to make, I want to say our jobs, because I was a trial lawyer for too long. It's going to make the jobs of the lawyers harder, but in many, many, many ways, I think it's going to make the jobs way easier if in fact you can potentially rely upon having the most current information at your fingertips without having to go back and say, Mother, may I?
We have now a sanctions provision with respect to the discovery, 1.280. You want to talk to us a little bit about that, and have you had to use it?
We do have a new section. It's under the rule 1.280. It's also under 1.380D or rule 1.380. Failure to make discovery sanctions is the name, and that's a good place to look. Failure to disclose or to supplement an earlier response. If a party fails to provide information or identify a witness as required by 1.280A or G, the party is not allowed to use this information or witness to supply evidence at any motion, at a hearing, or a trial, unless failure was substantially justified or was harmless. In other words, if you don't do what you're supposed to do by supplementing, it's going to come back and bite you. And I have the authority to do that.
Have you had to use that authority to date?
I have. I have done the analysis. I have not always imposed sanctions because the sanctions weren't appropriate, but I've gone through the analysis because I think it's important.
Are your sanctions sua sponte, or do you do it at the request of the moving party?
Depends. If the moving party moves for it, they're all sua sponte. I may agree. My sua sponte may agree with what was requested.
I try not to impose sanctions sua sponte unless somebody asks for it under those circumstances.
Oh, I'm sorry, I misunderstood what you said. Yeah. I don't impose sanctions unless somebody else asks for it. But I see a lot of people asking for sanctions for discovery violations.
More than before.
Yeah, I think that this has come up more frequently now than it has. What about you, Judge Tobin-Singer?
Yeah, generally, the only context in which I'm going to see someone raise a discovery violation is in the form of a motion for sanctions because they're prejudiced. So they want me to exclude it. They're asking for lawyer fees. And I most often see it after discovery deadlines have passed and the trial's coming up, and they get some when the joint pretrial stipulation is filed, which hopefully it is, and they see some disclosures that were never previously disclosed, they'll bring it up in that context. And I also see it raised during trial. And it's an interesting dichotomy between Rule 1.380 and then the Uniform Trial Order and the joint pretrial stipulation, because what would happen if the joint pretrial stipulation did not disclose, for example, a specific opinion of an expert? As you know, the joint pretrial stipulation is required to put forth all the opinions by an expert. What if it misses one, but it was disclosed in deposition? I've had that issue come up in the middle of trial, for example.
Sitting through many motion calendars, I have heard requests for sanctions, and I've heard a lot of requests for sanctions coming in the form of attorney's fees for attorneys having to prepare a particular motion to get discovery. How are you dealing with those motions? Are you reserving ruling? Are you granting them?
It depends. Also, it just depends on the circumstance. There are some circumstances under which I must impose sanctions under the new rule unless I find that there was some kind of good cause shown for not, for not having done the thing they were alleged to not have done. And so I try and make a record. I go through the analysis in all cases. It's because I have to.
It's been said that judges would rather put toothpicks between their eyes than conduct a fee hearing. With that in mind, I do try to get the parties to resolve the amount of the fees and the time frame without waiving the issue. But I really do try to avoid having a fee hearing over a sanction that comes at this level. So.
And later in this session, we're going to talk about the conferral obligations.
Yeah, we sure are.
And I would rather do the same thing that Judge Levinson just said to my eyeballs with pretty much every discovery dispute, because so frequently things are brought up on discovery disputes under either set of rules that don't need to be. And parties just need to sit down and talk and confer ahead of time. And I sometimes get the impression they haven't done that yet.
And we have a question that has come in with respect to supplementing initial disclosures. We've been asked, what is the best practice for lawyers to follow with respect to supplementing their initial disclosures? For instance, should we be checking each case on a monthly basis? Do you have a suggestion for us?
Yeah, I think you need to keep up on what's going on in your case. You have to supplement with any of the information that's in your care, custody, and control, or, by the way, that means care, custody, or control. You need to go out and plus, not that you shouldn't be keeping up on your case anyway for other reasons other than discovery. But yeah, I think that there's an obligation to supplement when you have the information, and you need to just stay on top of your cases.
Any advice to add to that, Judge Levinson?
Well, I mean, I think as a lawyer, just like as judges, you got to manage your case. So I don't think we as judges don't want to micromanage how you do your case. But when you become aware of something, you got to disclose it right away. I mean, one thing that we're looking to avoid, especially when we get to trial, are surprises. We're also trying to avoid aggravation, but that's another story. We're trying to avoid surprises, and avoid the surprises throughout this disclosure period and also the discovery process is to disclose. Two things: use your common sense and think about the golden rule. And if you follow that dictate, I think that things will work through it. I think that as things have evolved since post-COVID, so much of what we do is not personal. Rarely do we go to court now. Everything is by virtual. And that makes it difficult to establish the relationships that you need to help them work together to get to the bottom line, to get to the finish line there. And that's, well, as judges, we find it to be very frustrating. And I'm sure as lawyers, you feel the same.
I think that's a very good segue into our next topic, which is the meet and confer rule under 1.202. Since you were talking about that, Judge Levinson, would you like to expand upon
Yes.
that a little bit?
Well, what's the rule? The rule is, under 1.202, if there's before filing a non-dispositive motion, and under section C of the rule, it lists what you do not have to file or exemptions for the filing. The movement must confer with the opposing party in a good faith effort to resolve the issues raised in the motion. Now, when you file your motion, there has to be at the end of the motion and above the signature block, the movement must include a certificate of conferral and substantially in the following form. As it stands, I certify that prior to filing this motion, I discussed the relief requested in this motion, describing the method of communication and the date with the opposing party, and the opposing party either agrees or disagrees on the resolution of all or part of the motion. That's option one. Option two is, and that's when you cannot get a hold of the other side. The opposing party did not respond and describe with particularity all of the efforts undertaken to accomplish the dialogue with the opposing party prior to the filing of the motion, or I certify that conferral prior to the filing is not required under the rule. And in section C, it talks about things, again, makes sense why you would need to confer. A motion to extend service, obviously there's no one on the other side to confer with. A motion for default, injunctive relief, judgment on the pleading, summary judgment, dismissal for failure to state a claim on which relief can be granted, to permit maintenance of a class action, involuntary dismissal of an action, dismiss for failure to prosecute, or for directed verdict under 5.30, for garnishment, for writ of possession, for filed in actions proceeding under 5101, and also that do not require notice to the other party under any related or unrelated, any statute or rule. We've had a problem with that. Now, let me tell you how different judges approach it. I know for sure that there are some judges that will not, on a uniform motion calendar or otherwise, permit the party to have a hearing, or will cancel the hearing if you don't have the certificate of conferral. The way I have dealt with it, I do scrutinize and I look and see if it's in there. When they come before me at the motion calendar, I ask them, why haven't you conferred? And they give me all the reasons. What I do strive to do is get them, if it's virtual, to go offline and confer at that point. And I will tell you, the overwhelming majority of times when there is conferral, they have resolved the issue. And that's why we have the conferral. It saves time, money, costs, and fees for the client. And that's really what we're supposed to do. So I think conferral is a very important component. And as I said earlier, as a result of the evolution of how we conduct trials now, conduct proceedings in a virtual fashion, we are not getting the same level of conferral. I, as a judge, require, for most part, in-person attendance for the longer hearings, for special state hearings. I will tell you, routinely, I see people come in and say, Judge, I haven't been to court in years. Or Judge, it's so nice to meet the opposing counsel. I mean, this is the way it used to be. If you remember, when we had uniform motion calendar, the lawyers would go up and down the stairs, and that's when they would meet counsel, and that's when they would be able to work through many issues, not just the issues at hand. We're missing that now, and that is a frustration.
Jeff, Judge Levinson, what do you think about the manner in which conferrals are best had? I get so many, well, I texted them, or well, I sent an email. What is your thoughts?
Emails and text messages are not working. So when you come in and they say, I emailed them 4 or 5 times and then they didn't respond, the next step is I escalate it, and I will require any future conferral must be in person or by Zoom. At least they have to find the person to speak with them face to face. So that's what I have been doing. I have not imposed sanctions for non-conferral, but I've warned people that if it happens on a routine basis or in the future, I will consider sanctions. And I, like many of the judges, I know Judge Singer does this, is that I keep pretty copious notes on the computer online. So I can look back and see what I recommended the last time. And I will follow through if need be. So
Judge Levinson, I love that idea about making them come in person or at least doing FaceTime or Zoom conferrals if they don't confer.
it just
Yeah, I like that idea. I'm going to start doing that.
hard to get people to do things, but when you threaten them with coming to court, all of a sudden things get done. You know, someone on Zoom, I required the video. My video's on. You got to have your video on. I say, okay, if you can't get your video to work, we'll reset the matter in person. And magically, the video comes on. So it always works that way. Before trial, we have a requirement in our pretrial stip that you have to have the pretrial stip, joint pretrial stip, one set of jury instructions and a verdict form 10 days before. We give them notice a couple days before the 10-day deadline. If you don't get this in a timely fashion, you will have to come after the calendar call to an in-person pretrial conference. You know what? We're getting a lot of compliance because of that. People just don't want to come to court. What can I say?
And the bottom line is, I'm a big believer that if parties can sit down and honestly work stuff out, the resulting decision is going to be better than anything I can impose. It just is, because you're sitting down together and I don't have to pick a winner and a loser.
You know,
That's a great point. And I also agree that it's so important and so much more effective if you're talking to each other. FaceTime is even better, but at least on the phone. Texting, email, just not as effective or likely to reach an agreement or resolution.
The parties know their case way better than the judge or the jury. So you'll get a good result if you are communicating.
You all three bring up a very good point with respect to conferral. I have spoken to some of my colleagues and we have gotten a request for a conferral from somebody other than attorney, from a paralegal or from support staff. Does that constitute a good faith attempt at conferring, in your opinion?
No. Look at the rule. Look at the rule. It says you're certifying. So unless the paralegal is signing that, you have to certify that you discussed the relief or you attempted.
And another question that has been brought up with respect to good faith conferral is a definition of good faith. And I have, I've seen Judge Phillips's procedures, and in her procedures online, she defines good faith means at least 2 attempts to confer. Do any of the 3 of you have anything like that on your procedures? Do you think that we should have it there? Should it be on our case management orders? Any feelings on that?
Well, since the chief judge put it in her procedures, maybe it would be a good idea for us to do it. So,
would you follow the same good faith, or do you
sounds
think it
good to
should
me?
Okay.
No, and I think there, so often we get one side saying, I tried, and they look to be serious. And it takes 2 to tango, right? And so if you've honestly tried in a good faith attempt for real a couple times and they haven't, then I will very easily buy into a unilateral setting or whatever.
One of the issues that arises in my division is, we have deadlines for having a dispositive motion filed and heard. And a lot of times the motion's filed in a timely fashion, but it's not heard in a timely fashion. And I think a lot of my colleagues will consider that a problem and will say we'll deal with it during the trial. To avoid that, I always advise the lawyers, if you can't get the other side to agree on a hearing, set it down on motion calendar for a case management conference, because that is when we could help you get the case where you need it to be. But don't wait till 2 weeks or where the deadline's been blown and say, I couldn't get a hold of them, because at that point, it's too late.
Great point.
I'm sorry, I didn't mean to cut you
off.
I
just said great point, Judge Levinson. I do that too. If you're having a discovery issue, for example, let's say you've been unable to get some dates from the other side for depositions, don't wait until 2 weeks before the trial date when you've had this discovery issue for months. Bring it up right away. And like Judge Levinson said, if they're not agreeing even to a date for a hearing, then unilaterally set it on motion calendar for case management hearing. I love that.
If an issue arises where an attorney is faced with an impending deadline, and let's just take a discovery deadline. Discovery is due today, and an attorney is sick and is not able to get it in, they need to file a motion for enlargement of time. Under the new rule, that motion requires a conferral, correct?
Yes.
All right. And so now we're faced with shortened deadlines because we need to get that in. And so sending an email or picking up the phone and calling opposing counsel requesting such a short deadline puts a little bit of strain on both parties. How would you suggest that we deal with that?
Don't get sick.
Or I see that issue arise in many circumstances. Almost none of them are emergent.
Okay.
You know, people claim, oh, I haven't had a chance. I didn't do this. I didn't. But they did have the opportunity. They just didn't take it till the last minute when they finally realized.
And don't wait till the last minute.
Don't wait till the last minute. If it genuinely is, I just had a heart attack. I mean, if it genuinely is the last minute,
Yeah.
well, of course we're going to work something out.
I have never imposed sanctions when someone has a heart attack. I will assure you.
And frankly, I've never had an issue where there was a real, true, unexpected, unforeseen emergency that arose where opposing counsel is objecting if they agree. I mean, if somebody had a heart attack, they're not going to be challenging that.
Agreed.
Now, I have had in continuances where someone was getting married and they wanted a continuance and the other side objected. And I said, don't worry, we'll do the wedding during the trial, you know? So.
To digress just a little bit, we've gotten a couple of questions in that I think we could go back and address. One of the questions is, if a defendant fails to provide initial disclosures, what are the plaintiff's remedies?
There are several. Let me pull to the back of my notes.
Okay. Thank you, Judge Casey.
I can't find it.
Okay. What would you suggest? Obviously, the first thing would be to file a motion to compel, correct?
Yes.
Right. And assuming that the motion to the order was not complied with within the time required, what would the next step be?
And this is for what's
Initial disclosures, for a defendant failing to provide initial disclosures.
Well, the rule, there's a separate rule for that 1.380, which talks about sanctions for failure to provide discovery.
Okay.
And so you look to the rule and it says failure to disclose or to supplement an earlier response. If a party fails to provide information or identify a witness as required under the initial disclosures, the party is not allowed to use that information or witness to supply evidence at a motion hearing or a trial unless the failure was substantially justified or was harmless. And there are also other things that you can do. You can order payment of the reasonable expenses incurred. And there's even a section that says you can inform the jury of the failure to provide. I don't know how I'm going to do that. I don't think I'm going to do that. And impose an otherwise appropriate sanction. So, yeah, but the first thing is you need to promptly notify and then bring it to the judge and so that we can talk about it.
All right. And another question kind of following up on that. The question is, we're seeing parties provide limited information and or documents in the initial disclosures. And even after trying to prod that attorney, some attorneys are still not giving the required information. The question is the court going to entertain motions to compel in that instance?
I'll let you take that.
Yes.
Okay.
Yeah, me too.
That was
Same, of course. Yes, yes.
Although keep in mind, if they decide to sit on it, there are still sanctions available later that could be consequential.
And I think we need to segue into our next rule, which I believe is Rule 1.510, dealing with the motions for summary judgment. And I think Judge Tobin Singer, you've prepared a short slide show for us.
Yes. Yep. All right. Let's see if I can do this.
If not, we'll call the middle school kids over to help us.
All right, thank you. Normally my clerk helps. All right, so I'm talking about summary judgment, and hopefully none of us ever gets an order denying summary judgment with this kind of language where the judge in his order denying plaintiff's motion for summary judgment wrote, "At this point, the reader may be asking, is this some sort of joke?" It is not. The plaintiffs are actually making these arguments. So that's pretty radical. Anyway, I'm going to talk about the most recent changes to Rule 1.510, and if we have some time, I can talk about the changes that were enacted in 2021. But first, really, the changes I think that occurred in 2024, effective January 1st, 2025, have to do with when things should happen. So, for example, when can a motion for summary judgment be filed? And that wasn't changed, but I thought it was important to mention. You can file it as early as 20 days after the action has commenced. And so sometimes I get a question from a litigant. There's been an amended pleading. I filed my motion for summary judgment. Now there's an amended pleading. Do I need to file a new motion for summary judgment? Well, I think the answer is unless the pleading raises new allegations or claims that you feel like you need to address, then you wouldn't have to file another motion for summary judgment. Is there a deadline to file a motion for summary judgment? And yes, that is a recent change. It used to be that there was a specific deadline based on the hearing, 40 days before the hearing was set. But now that requirement is no longer there, and instead, the case management order is going to list the deadline for filing summary judgment motion. When are responses to motions for summary judgment due? Again, recent rule change. It used to be that responses were due 20 days. They had to have 20 days before the hearing to file a response. And that was problematic because sometimes motions for summary judgment would be scheduled, but no hearing was set. And so the other party never had to file a response, and we'd have a traffic jam and we couldn't hear the summary judgment because of other deadlines. So the rule changed, and now if you are going to file a response, there is a deadline. They're due no later than 40 days after the summary judgment motion is filed. Is there a requirement for a hearing on the motion for summary judgment to be set? And the answer is, if you are going to have a hearing, yes. And either the case management order or the uniform trial order will have that deadline. And Rule 1.510C6 says a hearing on the MSJ must be set for a date at least 10 days after the deadline for serving a response, unless, of course, the parties agree on another date or the court comes up with another order. Is a hearing required in order for the court to rule on a motion for summary judgment? As we know, in federal court, they can hear summary judgment and rule on summary judgment motions without a hearing. And so now that the language in Rule 1.510 has changed, is a hearing required? And I think one could make an argument that no, it is not. We'll probably get some case law on that eventually. I'm going to pull up now where you can see the actual changes. I got this on Westlaw. I'm sure there are other programs that you can get this where you pull up the rule and then there'll be an icon that you can press and it'll show you the previous, it'll compare the different versions. So as you see here, the deadline to serve the motion for summary judgment changed. It used to be 40 days before the hearing, and now it's with whatever the court order deadlines are. And again, Rule 1.200 requires that the court order that in the case management order. And then here are the other changes down at the bottom. God bless you, yes. Summary, a response has to be filed. I went over that. What I think is interesting about the language now is it doesn't say that you need to have a hearing. Before, under the old version, you had to have a hearing because otherwise there was no deadline for a response to be filed. So the case law interpreting the rule said, based on the language in the rule, you need to have a hearing. But I think, again, an argument can be made that you don't need that you don't necessarily need a hearing. Let me ask the other judges, have you had any arguments from one side, for example, that please rule on this without a hearing?
Never,
I haven't had, that hasn't come up yet.
never.
Okay, yeah, I haven't either. But I think, again, one could argue that. But so far, everybody just automatically assumes they want a hearing, and they, I think it might come up in the context where, because of the deadlines, there isn't time for a hearing. Perhaps the moving party might say, Judge, I'd like you to rule on this without a hearing. And so there might be some interesting case law developing on that.
But Judge Singer, so in my division, and I think probably in our circuit, and it was, I don't know if it still is, I think they're working on tinkering with that. The hearing, if conducted, had to be done 45 days before the calendar call.
Mhm.
And I feel that if it's not done 45 days before the calendar call, then I think in essence, it's going to be dealt with during the trial. And that seems to be a problem for a lot of folks. They do it at the last.
Right, and that's why I think that could be, that could be a very interesting appellate issue, Judge Levinson, because let's say that's your ruling. I'm not going to hear it because the deadline for having a hearing has passed. And then the moving party says, well, Judge, we would like you to rule without a hearing. The new rule, the changes to the new rule no longer require a hearing. So we would like you to rule on that without a hearing. And so, so far that hasn't happened. Nobody's raised that, but I think it's an interesting issue. And obviously, if both sides agree for the court to rule without a hearing, then we can. But I foresee a situation where the moving party, under our deadlines, can't have the hearing because the deadline's passed. And so they say, Judge, we'd like you to rule without a hearing. And the opposing counsel says, no, Judge, the rule requires a hearing. We want a hearing. And since there isn't time for one, we want you to rule. And I've always wondered about this requirement for a hearing, because all the arguments and all the evidence basically have to be filed ahead of time anyway. So nothing new can be raised at that hearing, theoretically. So I don't see why we really do need hearings.
I actually think a little differently. I really enjoy and I like the hearings because it gives me an opportunity to engage with the lawyers and it helps me make my decision. So a lot of times I go and I have a certain point of view, and then after the hearing, I change my point of view based on the arguments and based on the answers to my questions. So I think it's one of the things I kind of look forward to and I appreciate is having the hearings. And I think that we're going to talk about this later, but in circuit court, in state court, we really don't have much support from law clerks. We have staff attorneys that are overworked, and we really cannot give them too much work because they have, they're pulled apart from all the different judges. So when I tell people that I'm going to have my law clerk look at it, I say, I'm the law clerk, I'm going to be looking at it, and so that's additional time. If I have, look, we read everything before the hearing, I certainly do. But to have the lawyers go back and forth and explain it or answer some of the questions, from my perspective, it makes it a lot better.
No, I don't disagree with you, Judge Levinson. I wasn't saying that you don't get a hearing. I do think, though, that under certain circumstances, come on, we've all had some hearings on MSJs where there's clearly a conflict in the facts. Let's take first property insurance cases where we've got the competing engineers, and you know what your ruling is going to be. You can rule on the papers and nothing different. There's really no point.
Yeah, I agree with that. I agree.
So, but yeah, I definitely, I like having the hearings as well, but sometimes I also don't like to have unnecessary trials. So if an MSJ can resolve a case, then I might consider doing it without a hearing if I think it's clear cut. Obviously, if I read the motion and I read the response and I have some questions, I can always bring the lawyers in for a hearing.
Judge Tobin Singer, I have a question.
Sure.
The new rule for the summary judgments do not provide for a reply to be filed. How do you deal with replies, or have you had to deal with replies?
So you mean a response to the summary judgment?
A reply memo in support of the motion for summary
A
judgment.
reply to the response.
Correct. Thank
Oh,
you.
right. Okay. I'm fine with it frankly. If somebody, I don't think the rule precludes somebody from filing a reply, but most of the time I'm not seeing replies, to your point. And that can be something that's brought up to Judge Levinson's point, where he says he likes the hearings. There are times when I'm having a hearing and the moving party does argue something in response to, or I guess reply to the response. And under Rule 1.510, I'm allowed to allow a party to supplement the record with other evidence and that sort of thing. So I can consider it, but you're right, it's not a requirement, and I don't see it happening very often. What about you, Judge Levinson, Judge Casey? Do you see many replies?
I've seen a huge increase in people wanting to file replies. And there are two kinds. One is replies that are additional arguments in response to the reply to the arguments in the response, but also trying to add in new factual information and add in new things way past the time that needed to be provided under the rules. I think those are somewhat qualitatively different.
Right. Yeah, that's different. And I see late responses being filed.
Yep.
And since you did bring that up, Judge Tobensinger, how are you dealing with late responses since the rule requires them to be filed 40 days after the motion? Are they being stricken?
Well, I think it depends on the circumstances. Why was it late filed? How late was it? Was there prejudice? Because sometimes I won't consider it, but under certain circumstances, I will allow it. I think 1.510 does give me that discretion where I can, failing under E, failing to properly support or address a fact. Here, I'll pull that up real quick. Oops. Why don't I see it now? Hold on. Oh, you know what? The whole page is not, it doesn't show the whole page, sadly. Anyway, under E, failing to properly support, let me get rid of that. Failing to properly support or address a fact, it says that if a party fails to properly support an assertion of fact or fails to properly address another party's assertion, the court may give an opportunity to properly support or address the fact, or consider the fact undisputed for purposes of the motion, or grant summary judgment if the motion and supporting materials, including the facts considered undisputed, show that the movement is entitled to it, or, and this is very broad, issue any other appropriate order. So I think we have a lot of discretion as to how we do that. And so again, it depends on the actual circumstances in that case. If a person was clearly just not diligent, then I'm not going to consider it.
Judge Levinson, have you had to deal with late responses to motions for summary judgment and motions to strike them?
Yes, and it depends on how late it is. And I think as Judge Tobensinger said about the prejudice that would exist as a result of that. But I'm pretty flexible with letting it come before me so we can decide it on the merits as opposed to process.
And Judge Casey, I see you nodding your head.
I to the extent that I can fit it in under the rules, I always want to determine a case on the merits.
All right. And I think
Tammy, before we move
go
on
ahead.
from that, I just wanted to share with everybody this case that came out recently. That really, I thought, when I was, looking over the rule, it really gives a good summation of the changes. Let me find it on the screen. It came out last week. Here it is. U Restorations versus First Protective Insurance Company out of the Fourth. And it goes over the substantive changes that were implemented in 2021. So I don't need to get into the details now because it's kind of old news. It's been around for a few years, how we adopted the federal standard for directed verdict. But that's a good case to look up and read for a little refresher on the substantive changes.
Thank you, Judge. And I think we can segue into our next topic. And I think we wanted to discuss the case management orders that have been issued now here in the 17th Judicial Circuit. Judge Casey, you want to start us off on that?
Sure. The new rules have lots to do with case management, and it's under Rule 1.200. Remember that the rule doesn't apply to all cases, but it applies to the vast majority of cases. It doesn't apply to eminent domain or to confirm a foreign judgment, things like that. It applies to most cases, and it applies. We talk a lot about track assignments, and cases are set either in set in the division as either a complex case, a simplified case, or all the rest of them a case in the general. And that's important for timeframes and things like that that follow. Keep in mind, though, when we talk about complex, that's a complex designation in a regular division. We're not talking about, in that context, going to the complex tort or commercial litigation divisions. We're talking about treating a case as complex in a regular division. When you get a track assignment, there are ways under the rules to change that track assignment. A party can request a change, but it must be filed promptly after the appearance of good cause to support the change and must have a good reason for the change.
Judge Casey, with respect to the track assignments, what happens in the instance where a case has been assigned a track and 6 months go by and a new defendant is brought into the case and has to make an appearance? Is that new defendant going to be bound by the deadlines? How do you deal with that in your division?
It completely depends on who's the new defendant and what would be appropriate under the circumstances. Yeah, when a whole case management plan is conceived with X and Y as the parties, and you add, Z, B, A, D, and C to the end, frequently it needs to be changed.
And I'm assuming that motion.
Now, I also take into consideration, however, when we're looking at timeframes, whether any of the work that would have been done by the collective group was already done by the first set. And does there need to be duplicative this and duplicative that just because you weren't the one who got to ask the questions? Were the right questions asked? Were the right issues litigated? Things like that. So it really, like many things in our profession, it depends.
All right, thank you.
I mean, I think that time-wise, and the way we do it in our division is that we wait about 90 days. Hopefully, there'll be an answer filed, and we send out the case management order along with the uniform trial order. So it all goes out at one time, giving everyone a trial date and give them the deadlines that they need to comply with. And the case management itself is set in another 60 days. And what I do is I check the case management. I check the status of the case. If there's an answer and a trial date, then I cancel it. And unless they really want to come. The way you resolve these issues, when you have additional parties, when you have issues with discovery or whatever, case management conference. And I think you'll probably go into this at a case management conference. The judge has the ability to deal with any issue, any motion. We get motions to dismiss. I deal with them at the case management conference on a motion calendar, as a lot of people probably know that. So the idea is to help keep the case on track, help everybody on track to get a resolution, either by a trial, by a motion, or by settlement. And that's how we try to maintain.
Yeah, and the rules provide for all of that Judge Levinson was just talking about. Sub J of 1.200 says that a case management conference can be set by the court or by a party. The notice for the hearing must be reasonable. If noticed by a party, it must identify the specific issues to be addressed, which helps me a lot because as I'm preparing, I want to know why they set a case management conference so I can get ready for it. Issues that can be addressed include all scheduling issues, and with reasonable notice to the parties and with adequate time available, the court may elect to hear pending motions other than summary judgment or evidentiary matters. So they can morph into, with the right notice, they can morph into all pending motions except for a few. Our attorneys are expected to be prepared for case management, which in my experience, there has been. And there's a new part of the rule that talks about failure to appear at case management conferences. It gives us incredible authority. Failure to appear at a case management conference, the court may dismiss the action. The court may strike pleadings. The court may limit proof or take other appropriate action. So the idea is we need everybody getting together to try and manage the case together. We need you all present.
Let me say something. When that happens and we do, I either dismiss, strike pleadings, whatever, what it does, it wakes up the other side and they come back in and they try to undo that, which I'm pretty flexible about, but at least helps us get their attention so we can move the case. We can't track people down. So if they're given notice to be there and they don't show up, that's the consequence.
Yeah, I sometimes try and track them down. I sometimes ask the other party, have you heard from the other party? Because what I don't want is for them to have had their technology go out and there's a very good reason. Typically, there's a very good reason why people don't show up for hearings. I like to try and find that out before I.
That's actually a good point. I will, before I do take the action, I will ask if you can try to get them on the phone.
Yeah.
And then or bring them in so we can have them during the hearing that time. Usually we get somebody there.
That's what I do as well.
I'm sorry, Judge Tobin-Singer?
Oh, yeah. I said I do the same thing. When one side shows up, I ask, when's the last time you talked, try to get them on. And usually they do.
Either that or get a Snickers bar.
Let me talk a little bit about continuances, because that's an issue that comes up all the time and isn't addressed in the new rules. Motions to continue under 1200 C2 and under 1.460. It's pretty clear. Motions to continue trial are now disfavored. Full stop. And should rarely be granted, and those are both quotes, and only upon good cause shown. And here's the kicker. Lack of due diligence in preparing for trial is not grounds to contest the case. And I'm still getting them, and I'm getting them all the time. And people are flat out just saying, Judge, we didn't really pay attention to this case, and we need a continuance because otherwise, et cetera, et cetera, et cetera. There are reasons why continuances are required. For instance, for parental leave, when a legislative lawyer is in front of you and they're in session, things like that. Those are still by the books. But continuances are much harder to get. And they also have conscribed how the motion is to be brought. The motion should be filed promptly after grounds are discovered, must be in writing, and except for good cause shown, must be signed by the named party, not just the lawyer.
Are hearings required on those if they're agreed to by both parties?
I typically do, because I need to see who's available so I could reset. I immediately reset it at the same hearing, and I need to know who's available for what kind of a reset. And I want to, even if it's agreed, I want to have everybody there. I want to make sure everybody's really on board with this before we change it.
I think it's kind of peculiar for each division, and I and my division do not accept agreed orders to continue, because as part of our case management responsibility, I think we need to bring them in to find out what needs to be done, how long it's going to take, and to set deadlines. The way things are resolved from my experience is deadlines and decisions, and that's how things get done.
Judge Tobin-Singer, how about you and your division?
Again, looking at the circumstances, I will accept agreed orders depending on the circumstances. Again, like we were talking about earlier, if there's some unforeseen, unexpected emergency like a heart attack or something, I'll go ahead and rule the case. If it's agreed, all the parties agree. But other than that, generally, no, I would require a hearing. I also do not look kindly on these motions that are filed, but not timely set for a hearing. I had a situation recently, the case just settled, so I can talk about it, where a motion for a continuance, it wasn't titled that, it was titled a joint motion for case management conference. But what it was a motion for continuance, and the rule for case management says it should be in the title if you're, what the purpose of it is. And it wasn't. It just said joint motion for case management conference. And it was based on a lot of reasons, but the main one, which I would have granted perhaps if it was timely heard by me, had to do with a surgery by one of the parties that was occurring right before the trial was set to happen. And it wasn't brought to my attention until the jury is coming up to the courtroom. So I denied that, and then they lost, and then there was a motion for new trial, and I spent a lot of time writing my order detailing what, because normally that's unusual. I mean, if there's an unexpected medical situation, I'm going to grant a continuance. Just a few weeks before, we were picking a jury, and one of the lawyers got a phone call. His dad was in the ICU because he was bit by a snake. I declared the mistrial and continued it. But in this situation, if you don't bring it to my attention timely, I think I have grounds to deny it.
Are you inclined when there's an agreed motion for continuance or an unopposed motion for continuance and it's timely heard, are you inclined to grant that continuance?
Well, it depends, like the other judges were saying. If it's they didn't show due diligence before, like the case is 2 or 3 years old, and this is the typical kind of motion I'll see. The case is 2 years old or older, and they say, oh, we scheduled the depositions, but the witness is canceled. We had to reschedule because of an illness. Well, you started taking these depositions 3 months before trial. You've had 2 years. I'm not going to grant the continuance.
Have you had any notices of unavailability? I had a notice.
Of course, but I don't pay attention to them usually unless it's like I'm special set number 1 for trial on this date. Then I will recognize that. But sometimes lawyers will file these unavailability motions or notices because they're set for trial in 5 other courts. I don't really pay attention to that. What about you?
My last docket, my last counter call, I had a motion to be excused from the trial period for all 3 weeks. And
Right.
so instead of a motion to continue, it was a motion to
Yes.
be excused for the entire period. There's no such thing as a notice of unavailability. You can file a motion indicating that you may be unavailable because of other conflicts, putting all the details down. But I think the rules have eliminated that notice of unavailability.
Yep,
And
and that's rule 1.20 sub F.
It says.
No, they have no effect on the deadline set in the case management order.
Yeah, so I get those all the time, and I mean, they're helpful, but I mean, you got to be there. So
Agreed.
Judge Casey, before we leave our topic of case management orders, how do you deal with cases on your docket that are not reached and you roll them to a subsequent docket? When do they get rolled? How do you deal with attorneys that have unavailability during that time?
Yeah, the rule actually provides for the rolling of dockets as well. It's 1.200 sub H. If you're not reached on the docket, the court must enter an order setting a new trial period as soon as practicable, given the needs of the case and the resources of the court. Given the needs of the case, given the resources of the court, that gives us great leeway because we don't have the kind of resources that we would prefer to have. And the other thing that the rule says is the order rolling the case has to provide whether it means you're moving the deadlines or not, which is always an issue that comes up. So what I try and do is, depending on the age of the case, if the case is really old and needs to be tried, well, then I try to reach it on this docket. And if I couldn't reach it on this docket, I'll set it either the very next docket or at most the docket past that. I've got to get rid of my old cases. They deserve their day in court. Others, I will probably roll it for a couple of months, couple of times down, just keeping it alive.
And when you roll it a couple months out, do you extend the discovery deadlines and permit the parties to continue on with discovery?
It really depends. If in fact it's a fairly new case, probably. If in fact it is an older case where there's been plenty of time to get everything done, probably not. If the pretrial stip has been filed, I mean, if people are really ready for trial, I don't want to open it back up for discovery if they're already getting ready for trial.
Understood. Judge Levinson, how do you deal with that when you roll your case?
In the same vein, I will, depending on the age of the case, I'll roll it over to the next month or two. But I mean, if you look at your dockets and you see what you have and what's available. I had a case recently where the lawyer was tied up in a couple other trials. It wasn't his fault. He wasn't available in my trial. And so I sent him 3 months later. But we have a provision in our reset order which would require that the other deadlines remain. And usually in those situations, like Judge Casey has said, I would check that off and no more discovery. If they have to come back, they have to set a hearing and then we can deal with it. But generally speaking, that the deadlines are frozen and we just have to set it for the trial later on. And again, if the pretrial SIP and the jury instructions, everything's done, we're in pretty good shape to try it the next time. One thing I do also, especially when they're unavailable for personal things, I always say I'll reset it, but you got to be available in the next trial calendar. And we'll talk about when that is, but you got to be available the entire calendar. So to make sure that we don't have the same issues arise next time.
Judge Tobin Singer, how about you? How do you deal with that in your division with rolling the cases?
I pretty much just roll into the next month until they get resolved or get tried. And that being said, when I do that, I'm going to be more lenient about continuing. If I set a case, let's say for August, and I didn't reach it, and I roll it to September, and a lawyer files a motion that prepaid vacation or something, I'll roll it again because they couldn't have anticipated. I don't expect the lawyer to never go on vacation. And with so many of the lawyers, they have cases set for trial in many, many, many trial courts. And so it's one thing if I initially set it for trial in that month, I don't expect a lawyer to say they're unavailable all 3 or 4 weeks. But once I roll it, I'll consider it.
And Judge Tobin Singer, why don't we go ahead and talk a little bit about artificial intelligence and how attorneys are using and sometimes abusing that privilege?
Okay, sure thing. I have a little PowerPoint again. Let me get to it. Hold on. So artificial intelligence, is it a friend or a foe? Can everybody see?
Yes.
Yes.
Okay. Is it a friend or a foe? I think we could have a lively debate on that. But at the end of the day, I think it's both. It can be a friend and a foe, but either way, it's here to stay. And it can be a very helpful tool. Mitch Chester emailed me several articles about all the different software that's out there for lawyers to help them do their job. So for example, you could upload a contract and it will tell you the weaknesses, maybe clauses that are missing. I use on Westlaw co-counsel, which is artificial intelligence. And sometimes I find it helpful, sometimes not so helpful. I always check the case citations. Westlaw also has all sorts of ways that artificial intelligence searches can help you. There's one specifically for judges where a judge can upload a motion and a response, and then it will point out, it first of all checks all the case citations to make sure that the cases actually exist. And it also points out strengths and weaknesses of the arguments. I haven't found it that helpful really, other than to check the case citations to make sure they're real. But I think it's going to get better with time. So our case management order has this language in it that says that lawyers can ethically use AI technologies, but only to the extent that the lawyer can reasonably guarantee compliance with the lawyer's ethical obligations. And one of the biggest things that I've been seeing, and I don't know about others, is we're all so busy, judges and lawyers alike, that a lot of lawyers are using artificial intelligence. And we've been seeing a lot of this in the news, and I've seen it in my court, in my division, where lawyers file motions that have fake case citations. So it's happened a lot in federal court. I remember the first time it happened and it was in the news, I thought, oh my goodness, how could a lawyer do that? I'm sure no one will ever do it again, because how humiliating to be on national news, right? But it keeps happening, and I'm still seeing it in news stories. So I don't know why lawyers are not checking case citations. To me, that's very basic. But again, our case management order has a clause in there that if you're submitting anything that used AI generated content, you must include a certification that you have personally reviewed and verified the content's accuracy. And if you're too busy to do that, to actually pull up every case citation, there's software, there's Westlaw has a program, Lexis has a program, there's other programs where you can upload your document and they will check to make sure that the case citations actually exist. So our CMO says failure to include this certification or comply with this verification requirement will be grounds for a public stoning. Actually, I wish it said that, but no. It's just sanctions as allowed. But again, we've seen in the news that lawyers have been sanctioned by huge fines. I also think under certain circumstances, a referral to the Florida bar should be made. Public humiliation, I have brought this up a couple times during motion calendar, put the lawyer on the spot in front of 50 other lawyers. And yes, that lawyer should be embarrassed. And I hope that I don't see it anymore. But please, to me, it's so basic. Just if you want to use artificial intelligence, that's great to do your research, to do your writing, no problem. Just check the case citation. And ironically, every time that I've found a fake case citation has been to cite a principle of law that we know exists. Like the principle of law really is accurate. And maybe that's why the lawyer doesn't check the case citation, because they know, okay, I know this is the law. I don't need to double check the case. But you do need to do it. If you're going to file something, you need to double check that that citation actually is correct and the case exists.
Judge Levinson, have you dealt with AI in your courtroom?
I've dealt with it in that when I'm reading looking at the citations, some of the cases have been miscited, and it gives me some pause or concern. So I asked the lawyers to certify that they did or did not use AI, and if they did, please provide me with if they did not, provide me with a list of their citations. But I haven't had that issue arise thus far. Other than that,
Judge Casey?
I haven't had the issue arise either, thank goodness.
All right.
It's
Right.
just me then, I guess. I've had it 4 times.
Oh,
Wow.
hallucination.
Yeah, one time opposing counsel pointed it out in their response. Because again, I like Judge Levinson and Judge Casey. I think the three of us, we all read our stuff beforehand. But if I see a principle of law that I know is correct, I'm not going to look up the case citations. We don't have time for that. So I think, though, that's why maybe other judges haven't been catching it, because you don't read the cases because you know the principle of law. You don't need to read the case. But yet, there for different reasons, I have checked the case citations and they don't exist, the cases. And I start out, I send an email to that lawyer. Please email me a copy of this case. I could not find it. I'm sure they're sweating. They should be.
Well, thank you for speaking to us about artificial intelligence, Judge Tillman-Singer. That brings us to our last topic this afternoon. And Judge Levinson, you want to kind of start us off with, obviously, we've discussed this numerous times, professionalism within our practice, within our colleagues, and the additional stress now with these rules that have been put on us as well as the bench.
I think this is the basis for our mental health credit. So this is really hard for the lawyers. I don't know how you all deal with this. I mean, the pressures that they put on you now with the time constraints, with the deadlines. So we get that. But I just think we're all in this together and we need to work through that. It's really hard for us as judges to manage this stuff when there's so much infighting that goes on between counsel. It's not personal. You argue your position, they argue their position, and we make a decision. It's just really frustrating. So that's why I find that the hearings that are in person, you find a higher level of professionalism than you do on the hearings that are virtual. On virtual, you are not in essence face to face or in the vicinity of your opposition. Therefore, you can say or do things that you wouldn't do if the person was sitting across from you, right next to you. And it's just very frustrating. So I think that you need, again, at the beginning, think about common sense and the golden rule. Treat people as you'd want to be treated. And it's been very, very frustrating to see some of the, I don't hear, I had a case recently where the lawyer didn't say, well, the opposing counsel was mistaken. He had come to the court to say that I hadn't received a sanction check. And that was because there were some fires in California and that the HR office didn't provide it. He was mistaken. Well, the other lawyer got up there and said, Judge, he's lying. They're lying about that, and it was pretty obvious that it was an oversight. You're right. Maybe he should have checked more into it or otherwise. I don't know. But when you call people liars, when you call people, you hold people out personally, it just makes it really hard for all of us. So I think we need to kind of buck it up. I know, again, we're under a lot of pressure, a lot of stress, but we all need to get through it. And I will say this, we as judges are also have the same level of stress in that we have deadlines ourselves. Now we have to get our orders out within 60 days, or we report it to the Supreme Court. We have deadlines. We want to get things done. And just like Judge Tobin Singer, like Judge Casey, and I think most of my colleagues, we take this job very seriously. We make sure that we are prepared. We read everything, we show up on time, and we rule. And that's kind of what you're expecting from us. But it's hard. And we have, with the number of obligations within the cases, it stepped up for us. But make no mistake about it, whereas it may be stressful for us, the stress really lies, and we see that with you as lawyers, and we get it. But you need to step back, you need to think, and you need to really think about how you act professionally. We watch it all the time, and it can be very, very frustrating. We have avenues that we can employ or we can go through. We have a professionalism committee through the bar, the local bar. God knows we also have the bar, the Florida bar, which I try to stay away from and avoid making referrals if at all possible. So, but we all need to work together to get through this. And I think at the end of the day, when everybody's adjusting, and I think people are adjusting, I think we'll get a better product out there. Things will get done in a much more efficient manner. The whole idea behind these rules is efficiency. We shouldn't have cases that are 4 or 5, 6 years old. These people, the litigants, the non-lawyers, the non-participants, they want to get resolution of their dispute. And this helps us get them to get the resolution that they deserve. So hopefully we'll keep that in mind when we go through this process.
Judge Casey, anything that you'd like to add with respect to professionalism in our practice and the stress that these rules have put on everybody?
Sure. I had the great benefit of, when I was practicing, pretty much being able to get along with everybody else I was practicing against. And so I come to the bench with a naive expectation that everybody's going to be able to get along. And whenever I start to sniff out that isn't happening in the real world, and it smells odious sometimes, I just pipe up very quickly and say, hey, folks, being a trial lawyer is hard enough as it is doing the things. You can make it a whole lot easier if you just strive to be amicable or strive to be professional with the people on the other side. It's just too hard to you have to fight a contested case. And then in addition to that, in addition to having to fight the things you have to fight about, you fight about all the other nonsense like logistics and things. So I have a little lecture that I give, mostly have to give it to younger lawyers, occasionally have to remind older lawyers who at the end know what I'm talking about. I just expect it. And it usually happens.
Judge Tobin Singer, what about you?
Yeah, I think everything that Judge Casey, Judge Levinson said is spot on. I would add merely, think about your goal, which is to get ready for trial or to resolve the case. And you're going to be much more effective if you're professional and pleasant with the other side. And sometimes given, even if it's not always about, well, they're wrong or they, should have given me this already, try to work with them. And if you're nice, you can still be zealously represent your client, but be nice. And, judges, we notice who the professional lawyers are and who are the lawyers that are always fighting about things. And you get a lot more credibility with us if you are professional and nice and you pick your battles. So it just pays, like Judge Levinson said, golden rule, treat others the way you want to be treated, and maybe take a check and see. Is a lot of times I see it's about ego, or it's about, I want to show the judge that I'm in the right and they're wrong. Try to avoid that. None of us like to hear those kind of squabbles.
Judge Tobin Singer, do you mean that judges talk about lawyers?
Yes, we do. Yes, we do. Only if you stand out as either really good or really obnoxious.
All right. We have got numerous questions, so let me go ahead and start and see if we can get through these. The first question we have, we are seeing pro se parties using AI with fake case citations, but there seems to be no repercussions. How can the court deal with the problem with pro se parties?
In the same manner we deal with lawyers, strike pleadings, default, any type of sanction that we have, that's not acceptable. So, I mean, I would.
I agree. The law is that we can't treat pro ses any differently than parties that are represented by lawyers.
Are we going to give them one opportunity, two opportunities, three strikes and they're out? Have you had to deal with that yet?
Well, I don't know. Do we give lawyers one opportunity, two opportunities, or three strikes you're out? I mean,
I haven't had any situations with pro se citing fake cases. Only the lawyers.
I do try to empathize with the pro ses, the unrepresented, we call them unrepresented parties, I think now, and I let them know it's very hard to handle a case without the lawyer. But I say, listen, I think we all say this, we're all obligated to follow the same rules and apply the same rules to them as we would to an attorney, and they have to abide by those rules.
Yeah, and that's exactly what I do. I tell them that. I mean, I tell them, I'm not allowed to take sides. I'm not allowed to help you, but I will enforce the rules. I'm obligated to enforce the rules, the same against pro ses as against represented parties. And you've got to bring your game up if you're going to try and do this pro se.
Next question. Is it required to file your initial disclosures with the court, or is it sufficient to file a certificate of compliance with the court?
Please don't file your initial disclosures with the court. We have enough in the court files it is. I think you just should file the certificate. What do you think?
The certificate of disclosures. I think that's fine.
And then the follow-up question is, when you supplement your initial disclosures, is it appropriate to file just a notice with the court that you have supplemented your initial disclosures?
I say yes.
As do I.
Same. Yeah, same.
When dealing with hearing dates and not being able to obtain one, do you have a preference whether we contact your judicial assistant?
Yes, I'll take that. Start off.
Okay.
Yes, contact my judicial assistant, email her, and she'll check with me. And I think we all do this, where we reserve some time free of hearings just for emergencies, and also when we have extra time. So for example, during my trial weeks, I will set hearings on that Friday afternoon, because usually if I am in a trial, it's over by then. And so subject to cancellation, of course, if I still am in trial.
That is your most popular time, I'm sure.
Yes, I know. If I really want a hearing to resolve, I set it for 4:30 on a Friday. But No, I'm just kidding. But look, if the lawyers, I think, if they really want that hearing, they're going to be happy to get it, even if it is on a Friday afternoon.
Judge Levinson, is it
So-
permissible?
I think you can contact my JA. I get a lot of requests for non-evidentiary hearings to be more than 30 minutes. And it's rare that I accommodate, because if you give me the materials in advance and I'm able to read the materials in advance, I don't think anything should take more than 30 minutes unless there's something extremely complex. Again, non-evidentiary. So what happens is, but they'll ask for a little more than 30 minutes. I will look at the motion, and I'll tell my assistant to say, please set it on the special set docket. And that special set docket generally has has openings, because we hold that for the most significant thing. So the step is to contact the JA, and if it really becomes a problem, set a case management conference. That's the best way to handle these things if you can't get it resolved in that manner.
Judge Casey?
Same thing. I have to personally approve anything over 30 minutes on the special set. And I will, if it's evidence, but I want to lay eyes on it first before you take up valuable real estate, which is my special set calendar. And frequently I will address, you can call my JA. She'll probably just tell you what I just said, but you can call her. Otherwise, just set it down on the case management conference and we'll talk about it.
One more thing to add, when you go before the DCAs and you have oral argument on a whole trial or a whole matter, a whole case, how much time do they give you? 15 minutes, half hour at most? I mean, it's not a lot of time. So it seems to me that the motions that we get, we can get it done within the 30 minutes. And that's why. But there are exceptions, and I will consider it. But as a general proposition, usually 30 minutes. It takes some lawyers 30 minutes to say hello. In those situations, we have to consider more time. Yeah.
On issues that you have taken, motions where you have taken under advisement and have not issued a ruling from the bench, is there a time limit within which you are required to?
60 days.
60 days.
Yep, set by, I think, the Supreme Court. You have to, we are required to keep a log of everything that is currently under advisement, and the order has to come in within 60 days.
I would say 99% of the time I rule from the bench. And again, I'm able to rule from the bench because I've done the preparation up front. I've read the materials, so I have a good handle on it. So then once I hear the argument, I can make a decision. I think that what I've heard from the lawyers and some of the litigants is that's what they want. They want a ruling as opposed to taking it under advisement. We take it under advisement. Sometimes it takes us a while and I have to refresh my recollection. I got to read through the transcript and it just delays things. And I think the better practice is to try to rule.
In the event an attorney doesn't have a ruling within 60 days, would we be permitted to file some sort of notice with you?
I would appreciate it.
Yeah, we want to know that if it's a problem.
There have been circumstances where people were supposed to send in competing orders, and I was going to look over the competing orders, and they think they sent them. I don't think I got them, and that helps me. Oops, let me figure this out and what happened.
Judge Tobin Singer?
No, I agree with Judge Casey. I hope if you haven't gotten an order from me within 30 days, frankly, please email my JA, email my Division 21, and my JA will say, hey, Judge, what about this? And most of the time, like 99% of the time, it was something where I thought the parties were going to upload competing orders, and maybe they did, but I don't see them. That happens, but it doesn't happen very often, but occasionally, yes, I will miss it. And so I appreciate the lawyers emailing me sooner rather than later. So I would say for me, 15, 20 days after I've said I'm going to rule, or after a hearing, if you haven't gotten a ruling from me, please email me and let me know, and I'll get right on it.
One thing to bear in mind, unlike the PACER system in federal court, we don't get copies of motions that are sent to us, that goes to the clerk. So if you have a motion for rehearing, you don't get it. You don't necessarily get a hearing on that, but we have no idea that it's been filed. You're obligated, if it's a motion for disqualification or recusal, that has to be served on us. But generally speaking, I think you should operate on the assumption that we have not gotten any of those type of motions so that we can at least rule or decide those motions. And by the way, if you do contact us to remind us about the fact that we haven't ruled, I promise not to rule against you.
And you know what, if I could just add on to what Judge Levinson said, the motion for rehearing, I've had several appellate opinions, because we do get those, where they kick back the case because there's a pending motion for rehearing that was never ruled on by the court. And like Judge Levinson said, it's because I never knew one was filed. When a case is over, when I've made a final judgment, that's it. I'm done with the case. I'm not checking that case to see if anything was filed. So if you do file a motion for rehearing and you want a ruling on it, at least email it to me and let me know. And if you want a hearing, let me know that too.
In the same vein, okay, when we have hearings, let's say, for example, a motion calendar, please try to file it a couple days before the hearing. I had a hearing the other day and we filed something 2 a.m. Look, I'm good, but I'm not that good. I'm not going to be up in the middle of the night checking the docket, I can assure you. So if you want us to be prepared and you want us to read the stuff, get it to us well before the hearing.
Next question. Do the case management orders provide for non-binding arbitration or just mediation?
Just mediation, except for the property cases. Property cases, it provides for non-binding arbitration.
And then the follow-up
Is that
question.
correct? You guys agree with that?
Yes.
Yes. Yes.
And then the follow-up question would be, under what circumstances would you enter an order to send parties to non-binding arbitration?
Outside of the property cases, I do it very sparingly because of the expense. But if it will help the parties get together, or if the parties ask me to order it, I will. But it's an expensive proposition, so I'm reluctant to do that in cases outside of the first party cases. I don't know how you are.
Yeah, and sometimes one of the parties will ask for it. And I really, really want to take the temperature of the other party, because like I said before, in issues of resolution together, it really takes two to tango. And if one party just wants to try and the other party is dead set absolutely against it, I'll take that into consideration, because I don't want anybody wasting their time.
I agree.
It's a pretty good 3-judge panel here, isn't it?
Next question. We often hear in PI cases that a video will not be released to the plaintiff before the plaintiff's deposition. This seems to be exactly the kind of withholding the rule for initial disclosures is intended to prevent. Any thoughts on that?
I don't think that's something we should address, because there's case law on that. And I think we all rule in a certain manner. So I would be reluctant to actually speak on that. I mean, I approach every case separately, but there are different ways to approach it. There are decisions in that process on all sides of the issue. That's how I would.
Yeah, it depends. I have a typical way of ruling in those cases, but it's based upon the facts of the individual cases.
Right. Judge Tobin-Singer?
I agree.
Okay. Back to initial disclosures and computation of future economic damages. Typically, this involves an expert opinion. Is the party required to disclose this expert opinion with respect to initial disclosures, or are they permitted to wait until expert discovery?
They're required to give the computation of damages that they have at the time. And you typically don't have an expert employed in the very beginning. However, there are going to be, remember, keep in mind, disclosures are not just information and calculation, but they're also the documents upon which the calculations are to be made. And you very well may have those in your possession early on, and need to disclose those. Even if you don't have a concrete number, you need to disclose everything upon which a concrete number could be had, to the extent that you have it at the time.
Next question. In the instance where one side blows the deadline to file a response to a motion for summary judgment, is that a situation ripe for ruling without a hearing?
I think that's a good question. Whether, again, is a hearing required under the rule? I don't think that it's clear. I think that an argument can be made that the court could rule without a hearing, but, we'll have to see what the appellate courts say if that issue is raised and preserved. I haven't had that issue come up yet. So far, I've always had hearings on the MSJ, or if the deadline for a hearing is passed and I say I'm not going to have it, nobody's brought that issue up.
And I guess the follow-up question would be, in the instance where the 40 days has run and the party filing the motion for summary judgment wants a hearing, and they filed a motion for, or they don't want a hearing, and they filed a motion for the court to rule on the papers, would that be appropriate?
That's a really good question. I think I'd have to hear what the other side says on that. If they want time to file a response, I'd have to hear, why didn't they timely file the response? And my ruling may be, I'm not going to allow a response, whether I have a hearing or not.
And I think the law is pretty clear. Even if no response has been filed, you still have to make a finding on the record whether independently there's a sufficient basis if you do grant the summary judgment. You don't just grant it automatically because there is no response.
Right. Yeah, there's case law on that where trial judges have been reversed because just they had that same mistake in logic where, okay, there was no response, you win. No, you still have to make findings of fact, and it still has to lead to the proper granting of a summary judgment. I've had hearings on summary judgment where there was no written response filed, but they argued at the hearing some points that really should have been in writing, but I allowed it and denied it.
Or the motion itself might be insufficient on its face.
Well, that's what I'm talking about.
Doesn't-
Yeah,
it
I
doesn't
should have made, I
address
should have
it from different
clarified that the
fences. It
motion,
doesn't-
right. Yeah, to clarify that they can't argue at the hearing something, evidence that hasn't been previously argued or submitted, but simply that the motion itself is legally insufficient.
Next question. If we have supplemental information after initial disclosures, but now we have opposing counsel who has propounded discovery, do we have a duty to supplement the initial disclosures, or just put it in the discovery responses?
The rules for supplementation say that you need to supplement promptly unless the new information is already included in the discovery in the case. So you don't have to do it twice as long as it's clear that it's out there, but it needs to be clear that it's out there.
Next question. What do we do when we are trying to set a hearing or a deposition and opposing counsel is not responding to repeated requests? The motion requires a meet and confer, which is hard to do if you're not getting a response.
Case management conference.
Exactly.
Yeah.
And just put in that certificate. Do you need a certificate of conferral for case management conference
No.
on that? No. Okay.
Well, you can't unilaterally set it. You try to contact them to do it
Right.
at a convenient time, but if you're having trouble getting a hold of them, that may be a problem.
I'm sorry, I'm trying to get through these. Is there anyone on the panel aware of any efforts to take the practical experiences of trial lawyers and judges into consideration for possible refinement for the new rules?
Well, we have some people on the call who are with the Rules Committee. I'm on the Rules Committee, and I know we have our chair on the Rules Committee. So I think you've got to make the request. If you have issues with the rules, you need to make a request with the Rules Committee of the Florida Bar, and those are the way things are considered in that regard. So.
With respect to conferral and multi-party litigation, for instance, when you have 8 to 10 attorneys, do you have to send an email to each attorney asking whether or not they agree or disagree with the relief you are seeking?
It's a
Yes.
practical matter. But you send it. Why don't you just send an email to all of them, put them all in the email?
Right.
Yes. But I think the point is you need to hear from all of the attorneys that are in the case before you can go ahead and complete your certificate of good faith.
Is it pertain to all the lawyers, all the parties? I mean, sometimes it's only
I
one.
think you do. I think you do need to hear from all of them. And if you didn't, again, the certificate of conferral just says you got to put in what you did, what your efforts were, and yeah, you'd have to put in who you heard from and who you didn't. And if it's something that is a significant issue, I think you should try to talk to them, have a Zoom conference or something. Don't just, again, something that we talked about earlier, don't just email or text and put that in there. I sent 2 emails and never heard back. Pick up the phone. Pick up the phone.
And if need be, you know, if in fact there's just way too many parties on one side, we could get together at a case management and talk about whether you need to have lead trial counsel for that side who can kind of spearhead efforts, certainly about logistics.
Reach out and touch someone.
All right. We have another question with respect to initial disclosures. Plaintiffs are serving discovery with their complaint, but not serving their initial disclosures. As a defense attorney, am I required to respond to any of the discovery, and more importantly, the request for admissions?
It is not completely clear from the current state of the rules how the interrogatory section of the rules says when the interrogatories can be sent out, and how the new initial disclosures part of the rules say. So there could be a conflict. I think it would be treacherous to rely upon the idea that you can, under the rules, serve interrogatories with your complaint, not serve the initial disclosures, and expect for the next 60 days, and expect for those answers to come in first. If it comes down to an issue, I would summon up a case management conference really quickly.
I have nothing to add.
A question with respect to expert disclosure. Expert disclosure is required to be made pursuant to the trial orders. And expert disclosure requires providing deposition dates for the expert, as well as a handful of information that is normally covered by the expert witness interrogatories. The question is, when a party discloses their expert, are they required to provide that additional information that the expert witness interrogatories ask for, or can they wait for the expert witness interrogatories to be propounded? Any takers?
Well, sure. If I understand the question correctly, it's saying, do I have to disclose pursuant to the uniform trial order all of the opinions of the expert, or can I just do it when we respond to the interrogatories? And I think my main concern is that joint pretrial stipulation, which isn't due until 10 days before the calendar call. But I care about, in that joint pretrial stipulation, make sure that whatever opinions you want that expert to make, put that in the joint pretrial stipulation. Number one. Number two, if you're going to depose the expert, then that party's expert needs to make sure that they give the other side ahead of time all the opinions that expert's going to be testifying to, so that they're not surprised in deposition and not prepared to ask questions on that. So I think it's just common sense. We want to avoid surprises, make sure that the other side is on notice, whether it's in responding to interrogatories or otherwise.
And I think it also depends on what the case management order requires. Case management order may require more than just names of a disclosee, but some of the substance of what they're going to say. And case management orders need to be strictly complied with.
Right. And I think that the obligation to provide the opinions are a little more, I mean, it need to be sufficient. You can't just say he's going to testify that the standard of care was breached and there's liability. You got to give the opinion, and you got to give the factual basis for the opinion, so it's meaningful. So the other side can utilize that. If it's before the depo, then they can take a proper deposition.
Next question. What if the plaintiff does not have a computation of damages with respect to initial disclosures and states that they will be calculated and supplemented? Is that sufficient?
Well, when you file your lawsuit, shouldn't you have some idea what your damages are?
You certainly are certifying that it's above $50,000 just to get in my court. So you must have some idea. I find, could there be a situation where it's impossible to know? Perhaps, but you have to have investigated your case sufficiently to know that you have damages that were caused by, and you should have some idea of what your damages are. It doesn't have to be final, and of course, it can always be supplemented in the future as new things come up.
I agree. I don't think you should just say, we will supplement it later on. You got to have some idea when you file your lawsuit. At a minimum, you got to know at least what's the jurisdictional basis for your damage.
I agree. And I think just saying over $50,000 even isn't enough. I think the other side has a right to know a range of what you're asking for. I had a case that went to trial where it was before these rule changes, and had the defense known the full extent of damages that the plaintiff was going to ask, I think the case would have resolved instead of going to trial. But they didn't know. The plaintiff didn't give a number, and the defense didn't move to compel. So I didn't know about it until very late in the litigation process.
And as I looked through the rules, I didn't see a line that said, oh, I need to not give you this answer because I'm trying to dodge removal to federal court. That's not an excuse for giving your proper computation of damages.
Another initial disclosure question. If the plaintiff has served initial disclosures, but defendant has not, plaintiff is not precluded from serving discovery on defendant, correct?
Correct.
All right.
And it's not an excuse for you not to serve yours because they didn't serve theirs.
What is the court's position on a disclosure by plaintiff that does not include the computation of damages for each category, but rather responds by saying, see the attached medical records?
Not enough.
It really just literally says, you got to give me a computation of damages for each.
I agree. The overarching principle, again, is due process and lack of surprise. So lay your cards on the table. That's what you need to do. And even if it changes later on, that's fine, but at least give an initial disclosure. The defense needs to know that.
What constitutes a reasonable amount of time to supplement? 5 days, 10 days, 30 days? I think I know the answer.
5 days from what?
I'm assuming 5 days from when you find out.
I would say as soon as possible. As soon as you find out, you disclose, period.
I think that's the rule.
I'm seeing a lot of duplicates, and I think we've covered a lot of this. With regards to discovery, since we have HIPAA and plaintiffs can disclose all providers, would you limit the defendants to subpoenaing the larger amounts of the past medical records to try to find other undisclosed providers? I think this goes to the proportionality question back in discovery that we were discussing under the new rule.
I would hate to weigh in on that because that's on a case-by-case basis.
Yeah,
Agreed.
It all depends.
Yeah.
All right. I think it looks like we have had about 54 questions today. If your question has not been asked, please email it to abotaftl@gmail.com.
Each question will cost $5.
And do we have a CLE
Joke. I just wanted-
case number? Okay. I've been told that we are going to go ahead and email the case number to everybody that has been on here today. Thank you very much. If you would like to receive the ABOTA Fort Lauderdale newsletters, please email us also at abotaftl proportionality@gmail.com. I would like to thank our judges today, Judge Tobin Singer, Judge Dan Casey, and Judge Jeff Levinson for joining us. And thank you to Alex Rosa.
I do want to correct one thing, though. I graduated from Johns Hopkins University, not John Hopkins, just to let you know that.
Apologize, Judge.
No, I'm not from Pittsburgh.
Talk about being called out in motion calendar. Thank you very much. Thank you, everybody, for joining us today. I hope this has been informative and helpful to everyone. Have a good afternoon.
Bye. Thank you,
Thanks,
everyone.
everybody.